later, Kristina ran a solo practice devoted to advising employers in employment law matters and representing employees in a wide variety of employment disputes. In order to broaden her understanding of the employer-employee relationship, she subsequently specialized in complex business litigation at Stris and Mayer, LLP, focusing her practice in areas of employment, employee benefits, and healthcare litigation. Upon joining Landegger's new name, Kristina discovered her passion for educating, training, advising, and defending employers in all areas of employment law. She is a regular presenter before many HR and business organizations, including the Chamber, and in 2019, she was elected to our board. Kristina is a member of the Labor and Employment section of the State Bar of California, the San Fernando Valley Bar Association, and Eastern European Bar Association. And with that, we're going to turn it over to Kristina. And Fumi, are we going, I think we're going to mute everyone except for Kristina, correct?
Yes, I'm going to mute everybody right now.
Yeah, and then, well, hold on. And then you can put your questions into the chat window, and then we will take them either as we go. I'll bring them up to Kristina, or we'll take them at the end.
Yeah, I would actually prefer that we take them at the end because there's a very long list of things we got to cover. So I want to just zip through it.
Okay, so let's mute everyone and get going.
Kristina, you have to unmute yourself.
Can you guys hear me?
Yes.
All right, great. So good morning, everybody. Happy Friday, and thanks for joining us. As Nancy said, I'm Kristina Kourasis, and I specialize in employment defense. So I'm here for any advice, creative solutions, and God forbid you ever get sued, I'm here to help defend against any litigation. So let's get started with this power slide. And as I said, I'd like to hold all questions until the end, but you are welcome to send them over to Nancy, and we'll try our best to address them at the end, time permitting. All right, let's see. So as Nancy mentioned earlier, we've got lots of updates to cover. You know, we were yet busy in 2021, and there will be some very broad changes implemented in the way that we employ employees, and these changes are going to directly affect you moving forward and the way you operate as a business. So at the top of our list, something was just handed down to us yesterday. So we're still sort of getting up to speed on it, but it affects the way that we're able to classify independent contractors. I know this has been a hot topic for a couple of years now. And so I think that we're getting a little more good news. So here's what's happening. As a quick recap, the ABC test, as I'm sure you recall, was handed to us and then later codified as Assembly Bill 5, AB 5, which became into law in 2020. And just as a recap, you can only classify someone as an independent contractor, assuming 3 conditions are met. The first one being is only if they themselves control their work, if their duties fall outside the scope of your business, and if they have an independent business doing that work. So then in September of 2020, AB 2257 went into effect. And I think that what it was essentially, the effect of all these people trying to lobby and, essentially oppose what's been handed to them. And because AB 5 has been really, really broad. And so AB 2257 essentially gave us a little more exemptions in certain industries. It also expanded a few current exemptions and created some new ones. So AB 2257 is actually a good thing for us, right? It's got additional carve-outs and exemptions. So some of the more significant ones, I mean, this thing, 2257 is a beast. And if anyone's looked at it, I'm sure you spent no more than 2 seconds looking at it because it's overwhelming. It's really long, it's complicated, but the significant portions of it is that, the good news is that it really, really adds a lot more exemptions to certain industries. And it actually significantly expands some of the previous ones. And notably, previously, the business-to-business exemption was actually fairly narrowly defined, and AB 2257 expands that narrowly crafted exemption in a manner allowing two sole proprietors to enter into a contractor relationship. So, I want to point out that that is a significant expansion of the previous exemption, and the previous one was just narrowly drawn and required a physical business location for the services performed outside of the hiring entity location, among 11 other conditions. So this essentially makes it easier for you to say, I'd like to contract with another sole proprietor. Here's an agreement that I have in place, and I don't have to jump through crazy hoops. So good news, woohoo. So for the new positions that were created by 2257, essentially what we'll have to do is determine, using the old Borello test, which is a multi-factor test, whether or not you should be employing that person as an independent contractor or not. And I typically take the conservative approach, so I'd be happy to, walk you through the, on a case-by-case basis to make that determination. And what was handed to us yesterday afternoon was a decision by the California Supreme Court that basically states that this rigid ABC tripart test is now retroactive, okay? So what that means is that, you as a business potentially are liable for lawsuits filed, years before the standard even existed, which is really unusual, but, there it is. It's now retroactive officially. And now I think that you've been hearing in 2020 how gig companies have been filing lawsuits. They've invested, over $220 million, try to convince voters to pass November Prop 22. However, Prop 22 won't shield gig companies retroactively. And currently, a lot of those companies are facing pretty complicated lawsuits. And what this Supreme Court decision handed to us yesterday essentially means is that if they lose those cases, right, trying to overturn the measure, then they face much bigger liability, much bigger penalties, and potentially end up going out of business. So that's sort of the bad news, right? And switching over to California minimum wage, this is something that we check in on every year. You want to make sure that you are definitely up to speed on this. So for larger employers, we're looking at $15 per hour, including beginning 2021. This is the state minimum wage, okay? And so beginning January 1st, the state minimum wage, if you're an employer with 26 or more employees, became $14 per hour. And if it's 25 or less employees, it's $13 per hour. And I also put out the local minimum wage because there's a difference here. Take a look. It's beginning July 1st of 2021. It goes up to $15 per hour if you're an employer with 25 employees plus, and to $14.25 for employers with 25 or less doing business within the city of LA. And what that means is essentially at least one of your employees does, 2+ hours of work per week in the city of LA. So here's a chart that I have for you for ease of reference. Take a look at it. I have this, next to my desk. I look at this every day. You should as well, just to make sure. What I recommend also is do a quick audit, depending on how many employees you have. Just do a quick run through. If you have exempt employees versus non-exempt hourly, if you do business in the city of LA, make sure that they meet that hourly requirement. Here's the annual salary requirement. It gets bumped up. If you look at 2021, beginning January 1st, if you have 25 or less, we're looking at $54,080. that's what your annual salary should look like. And if you're 26 or more, it should be no less than $58,240. Okay, and this is, I have also the weekly salary here, so you can double check to make sure that you're paying enough. This is something that we discussed last year, but it applies this year again. So this was enacted in 2016, and it requires a workplace retirement savings program for private sector workers whose employers don't offer a retirement plan. And here are the deadlines. You know, if you have over 50 employees, the deadline this year is June 30th, 2021 to implement the program. So here's something that I know the chamber circulated earlier last week in an update. So there are significant changes to CFRA, and currently individuals who work for an employer with 50 or more, or I should say previously, it's no longer current, they were entitled to 12 work weeks for unpaid protected leave in a 12-month period if the employee takes leave to bond with a new child or to care for their own serious health condition. But effective this year, January 1st, the new law significantly expands the requirements for CFRA. So this is very significant, and I want to make sure that you take this seriously, review it with your supervisor, staff, take a good look, make sure that you're compliant, and maybe update your policy. Essentially, there are significant revisions, one of which is that the definition of family member has been expanded by this new version of CFRA. So what it does is it permits employees to take leave for a defined qualifying exigency related to covered active duty or call to covered active duty of an employee's spouse, domestic partner, child, or parent in the U.S. Armed Forces. So under the current version, these are kind of key takeaways that I threw in here for you guys so you can take a look. This is sort of something that is in a way bad news, but whereas before FMLA and CFRA, if you're a larger employer, could run concurrently, in other words, 12 weeks and you're done. Now, because of the expanded CFRA, that may not be the case because it actually creates, because of the broader definition of family and who you could care for, you could now, an employee could potentially now take up to 24 weeks of leave. In other words, they could take 12 weeks of leave to care for a sibling under CFRA, and later in the year could take 12 weeks off to care for themselves. So that could land in a 24 total weeks of leave in a 12-month period, which is, again, a huge difference from what we had before, but there it is. A few other things to note: because of this expansion, the new Parent Leave Act that provided bonding leave rights to smaller employers is now being repealed because it's no longer needed because of CFRA expansion, because the new CFRA essentially allows for that within its parameters, so to speak. The other thing that it does is it eliminates the key employee exception to an employee's right to reinstatement, which under the current law allows employer to deny reinstatement to employees who are among the highest paid 10% of the workforce under certain circumstances, but that's another change. And the other thing that it does is essentially it allows two parents, father, mother, 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 father, father, to be able to take 12 weeks of baby bonding leave. In other words, instead of 12 weeks, you can now have 24 weeks as a family. So this is AB 2399, which is an expansion to California state paid leave family benefits. And beginning January 1st, the extended paid family leave law covers employees who take time off to participate in a qualifying exigency related to the covered active duty or call to covered active duty of the individual spouse, domestic partner, child, or parent in the U.S. Armed Forces. And what 2399 does is it expands the definitions of care recipient, military member, and care provider for purposes of qualifying exigency. So I want to just go through and talk about, let me just see what's going on here. There we go. Excuse me. I think I had a wrong slide mixed into this. Let me back up. Excuse me. I think I somehow fast forwarded. There we go. Okay. There we go. Okay. Slideshow got a little fast forwarded. Give me just 1 second. Okay. So let's switch up to AB 2017, which is the employees are now allowed more, well, I should say complete autonomy for designating their paid sick leave reasons. So the reasons that they take paid sick leave for. If they want to take it for personal paid sick leave, they can. If they want to designate it as paid sick leave taken for kin care, they can as well. Essentially, AB 2017 permits employees to use 50% of their accrued sick leave to care for a family member, okay? So effective January 1st, 2021, AB 2017 modifies the normal labor code section 2233 to provide that the employee has the sole discretion to designate sick leave taken for kin care, caring for a sick family member. And I think that the rationale behind this was, you know, they didn't want employers to basically make the decision on behalf of the employee to say, okay, you know what, you've already exhausted your entire paid sick leave by, you know, caring for your daughter or whatnot, and making that assumption. So under the new law, making assumptions like that would be a violation of the law, and the employee will have to dictate how many days they're taking on, you know, to care for kin care as opposed to themselves. So AB 1947, again, what I do is I tell you briefly what there is to know under the existing law versus how it changes up. So under the existing law, employees who believe that they have been discriminated against in violation of any enforced by the California Labor Commissioner, they may now file a complaint with DLSE within 6 months after the alleged violation. Now, effective January 1st, 2021, this deadline has now been expanded to 1 year after the alleged violation. So essentially 1947 amends the California's whistleblower retaliation statute. And, you know, currently the California Labor Code 1102.5 doesn't provide for recovery of attorney's fees, but it now authorizes reasonable attorney's fees to a plaintiff who brings a successful action under that section, which makes it a little more risky to litigate and defend against an action like that. So let's hope you don't face one, and you know, we don't have to deal with attorney's fees. So 2992 expands protections for employee victims of crime or abuse. An employer is currently prohibited from discharging, discriminating, or retaliating against an employee who's a victim of domestic violence, sexual assault, or stalking, or for taking time off from work to ensure the health, safety, or welfare of the victim or victim's child. And effective this year, this legislation permits employees who are victims of a crime or abuse, or who obtain relief as a result of such crime, to take time off from work. And again, there are penalties for discriminating or retaliating against an employee. You know, I urge you to check in with employees. In the last several years, I've seen lawsuits to this effect, and this legislation simply is a movement to strengthen the employee's rights to seek time off, to protect themselves against an abusive spouse or an abusive situation in their family, boyfriend or whatnot. And I got to tell you, you have to be very careful and have someone who is competent, an HR manager, or if you're a solo or smaller business, make sure to check in with the employee, without asking them too many questions, but at the same time, err on the side of caution when you're letting them take time off, because I've seen some really damaging text messages, emails, and letters from employees stating, I'm being battered by my boyfriend and I need to, take time off, and then they get fired. So be careful to make decisions like that and at least investigate before you assume that the employee is, being disingenuous, because this is where a lot of litigation is taking place. So essentially what 2992 does is it expands protections for an employee, broadly defining victim as victim of stalking, domestic violence, or sexual assault. The second category is victim of crime that caused physical injury or that caused mental injury as a threat, and a threat of physical injury. And the third category is a person whose immediate family member died as a direct result of a crime. And the word crime is also defined according to this legislation. So AB 2143 essentially loosen restrictions on the no hire provisions in employment settlement agreements. All of 2020, we really sort of removed that limitation from settlement agreements that we were putting together for clients. Essentially, previously we've had a provision in there that basically says employee acknowledges and agrees that they will not be hired, for the, at this company. But 2143 essentially slightly loosens that restriction. And what it does is it requires that the aggrieved former employee must have filed the claim that they're making against the employer in good faith in order for the prohibition against no hire provisions to apply. And it also expands this no hire exception to allow no hire provisions when the former employee engaged in a criminal conduct, rather than limiting the exception to sexual harassment or sexual assault. So there is, slightly better news for companies, essentially, those who are facing litigation. So, this is good news considering 2020. This is relatively good news. So I want to just now switch over to COVID. And I know it's not our favorite topic, but I definitely want to make sure that you guys are prepared for this. A lot of my clients, don't understand the extent of this. If you're one of those people, don't feel bad. There's a lot of stuff that's been thrown out at us. Cal-OSHA has stepped up. There's also legislation in addition to Cal-OSHA. So I want to make sure that you're informed, but don't feel bad that you're confused. So under AB 685, which is effective January 1st, there are quite a few, I should say, additional requirements you should keep track of. The first key thing is notification requirements. And I want to make sure that you know exactly what notice you're supposed to provide to whom and when, because those are the key takeaways from this presentation. The notification requirements are supposed to go to employees that were potentially exposed to COVID-19 at work. And in some instances, the notification requirements are to the local public health agency in the case that you have an outbreak, and we'll go into that in just a minute, defining what an outbreak is and whether this notification requirement applies to you. And the bottom line is that you have to sort of be in your fear mode just for your own good, because Cal-OSHA now has expanded authority to enforce any violations. And by enforce, I mean they now have not just the right to cite you, they can also come out and, shut you down without absolutely no notice. and they have full discretion to make that determination. So you got to be really careful. So let's go through AB 685, which went into effect January 1st. First of all, who must receive notice? So all employees and employers of subcontracted employees. So if you have any employees, or I'm sorry, if you have any workers who are independent contractors, right, or subcontracted, you have to give notice to them as well, okay? And the definitions you want to keep track of that are in the next slide are qualifying individual within the infectious period, okay? So keep that in mind for just a second. Now, what information must be disclosed? You need to disclose that the individuals receiving the notice have been actually or potentially exposed, and you'll know that when you do your contact tracing. You talk to the employee who tested positive and you say, hey, where have you been? How long, how long do you think you were there? And who did you speak with? And then based on that information, that confidential information, you'll be able to get a better idea of who was potentially exposed. In that notice, in that written notice that you provide to the employees who were potentially exposed, you're going to also make sure that you inform that they are eligible for certain benefits and that they have certain options in terms of taking time off due to the exposure. And you also have to disclose what your disinfection policy or protocol was, that you've disinfected the place, and give them a copy of your safety plan, and also do your investigation to make sure that you figured out how the exposure might have come about. It may be that your cubicles are less than 6 feet apart. It may be that your break room allows 30 people to be in there, and 5 people per table without any masks while they're eating, right? So those are the kinds of things that clients are discovering is happening, and once they discover, they have that requirement of now figuring out, let's rule this out. We can no longer have that policy in place or protocol in place. Let's make sure that employees do not repeat this mistake. The timing of the written notice is within 1 business day of receiving the notice of potential exposure. And typically what happens is that an employee comes into work and says, I just received a text message that I was exposed, or, my family member just received their test result and they're positive, and I spent, the last, week with them. So it's whatever notice that you receive of the exposure, potential exposure. And then you also want to take note of you are now required to retain those records a minimum of 3 years. So what that means is that the letters, the notices that you send out to employees of this potential or actual exposure must be retained for a minimum of 3 years. Now let's go back to this definition, as I mentioned earlier, of all employees and employers of subcontracted employees who are on the premises at the same work site as the qualifying individual, okay, within the infectious period. Now, who is the qualifying individual? Okay, the qualifying individual is, as you probably suspect, is someone who has COVID, right? And this is how we look at it. So it's either a laboratory confirmed case of COVID. So they call you up and they say, I have COVID, I just got my test result. A positive COVID-19 diagnosis from a licensed healthcare provider, they can get a doctor's note stating that. A COVID-19 related order to isolate provided by a public health official, or, God forbid that happens to you, an employee dies, right? And now going back to within the infectious period, an infectious period is defined as, so for those individuals who test positive for COVID, right, with symptoms, it would be from 2 days before they first develop symptoms until 10 days after symptoms first appeared, and 24 hours have passed with no fever, without the use of fever-reducing medications, and symptoms have improved. Okay, this is for COVID cases, individuals who tested positive for COVID and developed symptoms. Now, for persons who test positive but never develop any symptoms, the infectious period is defined as from 2 days before until 10 days after the specimen for their first positive test for COVID was collected. Now, let's briefly walk through what an outbreak is and what your relative requirements are, or I should say obligations, to notify and who to notify if you have an outbreak. So an outbreak is has a higher, higher requirements for notification and reporting. So in essentially AB 685 defines an outbreak as if you have 3+ employees who have tested positive for COVID at the same work site, and the positive tests were within a 14-day period. And we can unpack this, but essentially the same work site means if you have, a bunch of buildings that you operate out of, and the positive case is in building A, and you have, additional cases in subsequent buildings that don't interact with building A, then the same work site is going to be building A, right? So if you have a warehouse and office space that are segregated from each other, then essentially if someone tests positive in the warehouse, then the people in the office space aren't going to be involved, okay? And then within the 14-day period is self-explanatory. The obligation that you have, so I'm sorry, just to make it absolutely clear, if you do have at least 3 COVID cases in the same work site within 14-day period, then you have what's called an outbreak. And the requirements that I have just gone through for notice and to whom and when involve a non-outbreak situation. So I am now going to cover notification and reporting requirements for a situation involving 3+ employees for an outbreak. So for an outbreak, you must provide notice within 48 hours of becoming aware of the number of cases that meet the definition of outbreak. And that may happen over an afternoon, as it has happened with a lot of my clients where they thought they were fine. And then later at 2:30, I got a call and said, you know what, my employees went out, got tested, and now 5 of them have COVID. So it can happen within a matter of hours. Be prepared for it. And this is sort of, gearing you up. God forbid it happens to you, but you'll be ready. So what you have to do if you do have an outbreak is you got to provide your local public health agency with the names, phone numbers, occupation, and work site of the employees who have COVID or who are now under COVID isolation order. And you got to provide a business address and industry code, which is self-explanatory, of the work site of where these individuals are, where they work. I think that it's sort of a scary thing, but at the same time, I feel like there's got to be a little leeway. And I think that we've got until February, but at the same time, I tell my clients, be really conservative with your approach. Cal-OSHA has now very broad enforcement power, and I don't want you to get a citation, but I want you to be aware that now under this statute, Cal-OSHA has very broad authority. They don't even have to give you any notice whatsoever if they determine that there's an imminent hazard to employees at your workplace. And that determination can be made independently of your knowledge. Sometimes employees call in. There's a lot of information online, and I have faced a situation with a client who had a Cal-OSHA arrive on the scene, and they had no idea that was going to happen. Apparently an employee didn't feel safe, and they just called. So please, if you have any doubts whatsoever, if you run a business that is within a specific industry, feel free to reach out, because there are very specific appendixes on there. For example, Appendix D applies to work office space. So if you have a work site that is an office, there are very specific regulations, very specific things that you need to meet. For instance, cubicles. Okay, if you have cubicles, they are supposed to be spaced at least 6 feet apart, regardless of whether or not you have, plexiglass barriers separating them. Apparently, the LA Department of Health has determined that unless you have an office wall, literally a wall separating you, if you have a wall, it can be less than 6 feet apart. But if you don't, then, your plexiglass dividers, for cubicles must be at least 6 feet apart. So, that's something that you really have to stick to. And if you don't, then, if an employee is disgruntled or doesn't feel safe, they can call up, or an inspector can just show up and issue a citation, including a shutdown. So you don't want to be facing that.
Kristina, there are actually customers calling Cal-OSHA and complaining about businesses.
Absolutely, Nancy. That is a really good point. I have customers, I have clients in the, health industry who are claiming that whatever services they're receiving are, not up to par, including caregiving and, helping. So whatever industry you're in, if you have any questions whatsoever, you really need to go and research. When in doubt, assume there are very specific regulations and requirements that apply to your industry. I think that, if you're in the city of LA, or I'm sorry, if you're in the county of LA, the county is very meticulous. They took a lot of effort, and there are different guidelines pertaining to different industries. And, chances are your industry has very specific guidelines in terms of, the distancing, the, sanitation, and all the other protocols. And if you have any questions, reach out to Nancy, reach out to me, or anyone, but don't make assumptions that what you're doing is okay, because this is now officially, Cal-OSHA has very broad authority for citation and shutdown. So don't make assumptions. So the other thing that a lot of clients and a lot of people are confused about is that Cal-OSHA has also issued regs, and they were sort of what's called ETS, which is emergency standards that were implemented in place because of the numbers rising. So it's called ETS. And back in November, Cal-OSHA issued emergency regs for prevention and testing. And those went into effect November 30th. Okay. Now, I don't think, to be quite honest, knowing what I know today, they're going to go back unless it was really egregious, a violation. I think that they're giving people, there's a grace period through, the end of January or maybe beginning of February. So if you're doing your best to implement a plan that's compliant, good for you. And if you're being blatant and ignorant, like, that's bad for you. They might come down hard on you. They might cite you, and it will cost a lot. They might shut you down. So be very careful. But the Cal-OSHA's emergency regs went into effect November 30th. And, they're still continuing while permanent regs are being drafted. But essentially what Cal-OSHA requires almost every employer, within very few, very narrow exceptions, is that you have to implement a site-specific written COVID-19 prevention plan. And Cal-OSHA actually has a really good template. If you go on their website, you can just steal their plan. It's really long and really complicated, but at the very least, you can go on their website and check it out, and you'll see sort of what, points you got to hit, and make sure that you have it implemented, and that you train your supervisors or whoever is being in charge of enforcing it, so that they're not clueless. And the Cal-OSHA's emergency regs, they require employers to implement training and notice requirements for employees. And many of these, this is where I think a lot of my clients are confused, is that there's an overlap between what went into effect in November, which is the Cal-OSHA ETS, emergency temporary standards and the AB 685, okay? There are a lot of overlaps, I gotta tell you. And to be quite honest, sitting here today, having looked at it so many times, I don't quite understand why there's so much overlap. But the bottom line is that many of these regs, they really mirror the requirements implemented by AB 685, including that information regarding available leave and benefits be provided. I can't even begin to emphasize how important it is that your employees understand that if they got COVID or if they got exposed at work, they need to understand that you will pay for them to be out. And this is the what's called exclusion pay. And exclusion pay is essentially a requirement for an employer to maintain an employee's wages while they are out. And they're out because they were either exposed to a COVID case at work or they actually are the COVID case at work, right? Now, you're not required to maintain exclusion pay if you have a reasonable belief, or if there's evidence, or if the employee themselves tells you, I got COVID while traveling, I got COVID on vacation, I was on an airplane, my husband got COVID through his employer, there's so many scenarios, right? But bottom line is that if it's clear cut that they got COVID somewhere else or they were exposed somewhere else outside of work, then you don't have to pay them what's called exclusion pay under the Cal-OSHA emergency regulations. And I know there will be tons of questions about that, and I'm happy to take them at the end. But the bottom line is that while AB 685 is aimed primarily at post-COVID exposure, Cal-OSHA regs are trying to essentially be proactive regs and try to prevent the exposure in the first place. So that's really the best, my best I can do to help you understand the overlap. So I just want to walk you quickly through the Cal-OSHA overlapping ATS, the emergency temporary standards. What they require is that employers offer free COVID testing during work hours. So if you have employees who are exhibiting symptoms, if you have one employee who says, I just tested positive, whether or not it's work-related, I want to emphasize for the person who tested positive, those other employees who were exposed, they must receive notice, and you must now offer them free testing for being exposed. And so they got to go get the testing done. It must be done during work hours, and you have to pay them for the time that they're getting the test. You must reimburse them for the time that they're traveling, for any mileage reimbursement, for any cell phone use, whatnot. I mean, I highly doubt that there will be a significant amount of expense reimbursement involving the travel or the cell phone. But for example, a few months ago, I had to travel to Culver City because they were the closest available rapid site. And I had to go and get tested, and I did. I got it done. It was at the Culver City Urgent Care Clinic. They give you, results within 15 minutes. There's a little bit of wait because there's a line, but ultimately, you get it reimbursed through insurance. If you don't, then the employer has to cover it. So you want to be very clear in your notification. It's got to be a written notification to your employees stating that, you're one of the people who we identified has been exposed, and you must go get tested. Put it in the written notice that you will cover the testing expenses, that they will get compensated for the time that they have to go get tested, and make sure that they understand what benefits are available to them while they're being tested, including, for exclusion pay, including, the time that they're getting tested, the time that they're sitting at home waiting for that test result. If they are unable to work remotely during that time, then they get exclusion pay. And essentially exclusion pay is your obligation to maintain their regular wages during any time that they're off work, including, the time that they're being tested, waiting for their test to come back. And you're basically allowed to, I'm sorry, I don't want to understate it. You are permitted, it's lawful for you to require that if they were exposed at work to COVID or they test positive, you are allowed to require that they use their regular paid sick leave to fulfill your obligation for exclusion pay. So in other words, you can tell them, John, I'd like you to, use your paid sick leave while you're getting tested, while you're out. The exposure is work-related, or at least you've done your investigation and you know that it is.
So Kristina, I just want to let you know that there's only 10 minutes left. This was scheduled for an hour, and we
Yeah.
have questions in the queue.
Okay. I think this was the most significant part, and it's fairly complicated. So I wanted to make sure that, let me just cover a couple more points. I appreciate you fast forwarding. So what I want to make clear, because I know a lot of people are confused, is that there were two major sources of benefits on the state and federal level that were in effect. One is the state supplemental paid sick leave that was applicable to, companies with 500 plus employees nationwide, non-food sector employees, who were employed by private entities with 500 employees nationwide. And then there were also, what this was applicable to is companies who had under 500 employees, but who employed healthcare workers and emergency responders who were previously exempted from providing FFCRA. So what I want to emphasize to you is that both the state supplemental paid sick leave under 1867 and the federal FFCRA have expired, officially gone over, done, bye-bye, December 31st, 2020. And what that means is that under state and federal, you are no longer required to provide those 80 hours of paid sick leave to employees. Under FFCRA, it's those 6 reasons. Under state supplemental paid sick leave, similarly. But under FFCRA, you are still allowed through March 31st to voluntarily offer to continue to provide those that 80 hours or up to 80 hours, depending on how many hours the employee works, and obtain tax credits, which in conjunction with exclusion pay, I'm recommending to all my clients who, when the exposure is work-related, and you know that the employee either got exposed or they got COVID at work, and you know that you're obligated to provide exclusion pay to that employee, go ahead and give them the 80 hours or up to 80 hours of FFCRA, because you're going to get tax credit through March 31st for doing so. Okay, so I just wanted to cover that before we move on to anything else. Nancy, if you want to jump into Q&A, I'm happy to do so.
Okay, let's do that.
Okay, let's do that.
So our office phone is ringing and my cell is vibrating on the
All
okay.
right.
Okay, is the minimum salary for exempt based on California minimum wage? Is it based on, or is it based on the county or city? So, the minimum salary for exempt employees, what is it based on?
Yeah, so the minimum salary is going to be $54.80 if we're talking
No, we know that, Kristina. Is it based on the minimum wage in the state minimum wage to get there, or the county or the city's minimum wage?
Well, it depends. I mean, it depends. If you're in the county, then if you're in the city, then you gotta abide by this. This covers you though, right here. This covers you, these amounts. I make it really simple. So don't worry about it. Look at these numbers. And if you have 25 or fewer employees, it's going to be this number. If you have 25 or more, it's going to be this number.
Okay.
It's not going to be less. This is it.
Okay. So don't forget, we're going to be sending out the slides, and this will be on our YouTube channel.
Yes.
Regarding CFRA, does the 5 employee count include the owner as an employee?
Yeah, absolutely.
So even if they're a sole proprietor?
Yes. If they list themselves as an employee on payroll, yes, absolutely.
What happens if the owner does not list himself as an employee?
Then no.
Okay.
Yeah, it's got to be someone who is listed on payroll as an employee.
Okay.
And a lot of my clients do that. So I suggest that you do it. Why not?
Okay. Do you have a notice template that we need to provide employees? Maria, I'm not sure where you asked this during the presentation. Can you unmute yourself and what notice are you looking for?
Hi, Maria.
Maria Khan.
Yes, I'm looking, my question is in regards to the notice that we have to provide to the employees when we have an employee tested positive.
Okay.
The
Is there a
notification.
template for that, Kristina?
There is something that I'm happy to provide to you. It'll have to be slightly tailored though, because I would need to know when was the last day the employee that tested positive was on the premises. We need to assess if the notice is even necessary, is my point. So feel free to email me or give me a call. My contact info is at the end of this PowerPoint, but we'll need to assess if the timing of the exposure, makes you, requires you to provide the notice. Okay.
Okay,
Yeah.
thank you.
You're welcome, Maria.
And can you refer employees to the free testing facilities instead of paying for the test?
Absolutely. Yeah,
thought.
I would recommend that. I was talking to a client a couple of days ago, and they basically said because of the surge in all the testing, that the drive-through free sites are now basically screening for symptoms. And so, sometimes if you have absolutely no symptoms and it was just an exposure without symptoms, they might not even let you go through. And so some people feel comfortable saying, oh, I have some symptoms, and other people just don't want to, which I totally understand. So that's sort of the
And then when you state potentially exposed,
yeah.
does that mean that the employee's brother who lives in the same household tested positive on Saturday morning and our employee was at work on Friday? And I feel like I need to draw this out. Does a notification need to go out to everyone the employee was around, although they aren't the one that tested positive yet?
No, let me make absolutely clear. The notification requirement is only triggered if an employee has tested positive.
Okay. And then is it okay to send the exposure notice via text message through a text app that a company uses, or does it have to be a formal letter?
No, I would use whatever the normal way of communication is.
Okay, that's all the questions in the queue.
Perfect.
Thank you.
Great, and feel free to reach out if you have any additional questions, and my contact info is at the end of this PowerPoint. And thank you for joining us today.
So before everyone hangs up, if you are a member of the chamber, you will be receiving a new employer poster for 2021, the federal and state poster for free. You get one poster for free. If you have employees that are 100% working from home, you have to provide them the same poster. You can't and you can't email it to them. So we do have those available if you need to purchase extras. If you're on this call today and you're not a member of the chamber, we will give you a poster for free for just attending this workshop today. So put your name and address in the chat and we will send that to you when they go out next week. Because we want to make sure all of our businesses are in compliance. So that way we could, protect you as much as we can. In addition, I want to point out, because I have this question, do not take down your LA City or LA County minimum wage poster. You still need that up. And some of you have them, some companies will sell them and they'll put the year on it, but the posters themselves have the multiple year minimum wage increases. You don't need to change the poster because some company decided to make that a way to make more money every year. Right. Just keep up the one you have. If you do not have a city or county minimum wage poster, let me know and I will send you the link because you can download that yourself for free. Did I cover that one good?
Okay. Kristina, do you want to throw up your contact info slide again?
Yeah, absolutely. Here it is.
And I know some people on this call are also HR people and you probably have clients. If you need to get your clients employer posters, please reach out. We do have discounts available for people who are giving them to their employees. We're very fortunate for our new relationship with the California Employers Association, who is able to bring them to us at a much better price point that we could offer them to all of you at a much better price point.
That's great, Nancy. I think it's so important. We have, you know, our posters in the kitchen, and I think those are really important in helping navigate employees. And like Nancy pointed out, you don't have to renew one if it covers all the subsequent years. Those are just, you know, money-making schemes. But if you have any questions, I'm here, and I'm happy to provide a free, you know, 15, 20-minute consultation to help you guys figure out what's going on. As Nancy pointed out, I'm on the board, and I'm happy to just help you figure out, you know, what you should be doing. And I don't care to make money out of it. I just really want to make sure that the San Fernando Valley is taken care of and compliant, and that we, you know, we'll get through this together.